Hello to everyone. Myself, Dr. Mrs. Sonali J. Gaikwad, Assistant Professor, DGB Dayanand Law College, Sholapur. In this video lecture, I shall be speaking of Hindu Adoption and Maintenance Act 1956 from section 18 to section 20. So let's move on. The word maintenance is a wide connotation. The precise exact definition of the term maintenance is provided under Section 3B of Hindu Adoption and Maintenance Act 1956. What does this definition basically say about? It states that maintenance includes all the provisions of food, clothing, residence, education, medical treatment, and medical assistance. And in case of an unmarried daughter also, the reasonable expenses of an incident to her marriage. So section 18, the verbatim of this section is maintenance of wife. Subsection 1 says that subject to the provisions of this section, a Hindu wife, whether married before or after the commencement of this act, shall be entitled to be maintained by her husband during her lifetime. So this section, this has retrospective as well as prospective. Subsection 2 says that a Hindu wife shall be entitled to live separately from her husband without forfeiting her claim to maintenance. But again, that is subject to certain conditions which have been specified below. If he, that is her husband, is guilty of desertion, that is to say, has abandoned her without any reasonable cause, without any reason, and without her consent or against her wish, or of willfully neglecting her. Clause B, if the husband has treated her with such cruelty that she has a reasonable apprehension in her mind that it will be harmful or injurious to live with her husband. Clause C, if he is suffering from virulent form of leprosy. Clause D says that if he has any other wife living, that is, if he commits bigamy. Clause E, if he keeps a concubine in the same house in which his wife is living or habitually resides with the concubine somewhere else. Clause F, if he has ceased to be a Hindu by conversion to another religion, that is, if he converts, if he has relinquished, he has the Hindu religion and converts to any other religion. Clause G, if there is any other cause justifying the wife to live separate. So as per clause G, if there are any other reasons besides clause A to F, then as per clause G, the court may have a jurisdiction to decide whether the reasons which have been stated by the wife are justifiable for her to live separately and claim maintenance. Subsection 3 says, a Hindu wife shall not be entitled to separate residence when she cannot live separately and claim maintenance from husband if she is unchaste or has ceased to be a Hindu by conversion to another religion. So two things are important, that is, she should not be unchaste or she must not have been converted to claim the benefits of this section 18. Section 19 speaks about maintenance of widowed daughter-in-law. As per subsection 1 of section 19, a Hindu wife, whether married before or after the commencement of this act, shall be entitled to be maintained after the death of her husband by her father-in-law, provided and to the extent that she is unable to maintain herself out of her own earnings or other property, or where she has no property of her own and is unable to obtain maintenance. Number 1, from the estate of her husband, that is, if she has not received anything from the estate of her husband, or from her parents, that is, her father or mother. And secondly, if she does not receive or obtain or is unable to obtain maintenance from her son or daughter, if she has any, that is, if any, or his or her estate. And subsection 2 says an obligation under subsection 1. Now what does subsection 1 says? That is, it an obligation imposed on father-in-law. So the obligation which is imposed on father-in-law as per subsection 1 shall not be enforceable if the father-in-law has not the means to do so from any co-partnership property in his possession out of which the daughter-in-law has not obtained any share, and any such obligation shall cease on the remarriage of the daughter-in-law. Moving on to section 20, maintenance of children's and aged parents. Now this provides for some other subsection, that is subsection 1. Subject to the provision of this section, a Hindu is bound during his or her lifetime to maintain his or her legitimate or illegitimate children and his or her aged or infirm parents. Subsection 2 says that a legitimate or illegitimate child may claim maintenance from his or her father or mother as long as the child is minor. So, till they are minor, they are eligible to claim maintenance from their parents. Subsection 3, the obligation of a person to maintain his or her aged or infirm parents or daughter who is unmarried extends in so far as the parents or the unmarried daughter, whatever the case may be, is unable to maintain himself or herself out of her own earnings, that is out of his or her own earnings or other property. And the explanation which is included in this section, what does it say? In this section, the term parents, now we are saying that aged parents have been mentioned. So this term parent also includes a childless stepmother. So if there is a stepmother who is not having any children, she is eligible as a parent to claim maintenance. Next is section 21, which specifies or defines what is meant by dependents. So for the purpose of this chapter, dependent means the following relatives of the deceased. Number 1, his or her father. Number 2, his or her mother. Number 3, his widow, as long as she does not remarry. So she is also a dependent. So if she does not get anything from the husband, then she can claim from those who inherit the property of the deceased. Number 4, his or her son or the son of a predeceased son or the son of a predeceased son of his predeceased son, that is son, grandson and great grandson, as long as he is a minor. So these 3 categories, generations, are termed to be dependents, provided and to the extent that he is unable to obtain maintenance in case of a grandson from his father's or mother's estate, and in case of great grandson from the estate of his father or mother or father's father or father's mother. Next, subsection 5 says his or her unmarried daughter. The unmarried daughter is again, she is having the right to claim maintenance as a dependent, or the unmarried daughter of his predeceased son, or the unmarried daughter of a predeceased son of his predeceased son, as long as she remains unmarried, provided and to the extent that she is unable to obtain maintenance in case of a granddaughter from her father's or mother's estate, and in case of great granddaughter from the estate of her father or mother or father's father or father's mother. 7th category of dependent is his or her widow. That is, we have seen about section 19, which speaks about widowed daughter-in-law. In the same way, a widowed daughter is eligible to claim maintenance as per clause 6 of section 21, provided to the extent she is unable to obtain maintenance under 3 conditions. A, from the estate of her husband, or from her son or daughter if any, or his or her estate, or C, from her father-in-law or his father or the estate of either of them. Clause 7. Any widow of his son or of a son of a predeceased son, as long as she does not remarry. Okay, provided and to the extent that she is unable to obtain maintenance from her husband's estate or from her son or daughter, if any, or his or her estate, or in case of a grandson's widows, also from her father-in-law's estate. Clause 8. His or her minor illegitimate son, as long as he remains a minor. And clause 9. His or her illegitimate daughter, as long as she remains unmarried. So where sons are considered, that is up to the age of majority, that is until they become major, or and in case of daughters, unless she gets married, that is as long as she remains unmarried. So these are 9 categories which have been governed under section 21, that is dependents. So this is all about section 18 to section 21 of Hindu Adoption and Maintenance Act. Thank you.